go ahead and introduce yourself and just tell us a little bit about why you decided to go to law school and where you went and kind of how that got you to where you're at right now.
Yeah, thank you. Um, my name's Hope Wood, and I have a law practice, Hopewood JD. It's law is my second career. I went to college initially to work in the exercise and health promotion field and did that for 8 years. And while I was in that field, I did a lot of managing of other people and projects. And one thing that I really enjoyed in my role as a manager was conflict resolution and problem solving. So when I was looking at starting a second career, those were the two skills that I enjoyed doing and I felt like I was good at.
Okay.
And that drew me to the profession of law.
When you decided like, hey, I want to go to law school, like how did that conversation go?
I decided and got accepted into Drake Law School in Des Moines,
Okay.
and it was the area that I wanted to raise a family in. So
Gotcha.
that helped. So I'm in Des Moines, planning to stay in Des Moines for my lifetime. Being able to connect with other attorneys that were practicing in Des Moines, and Drake does a great job of introducing you to judges. And it was a great experience. I actually just had my 10-year anniversary from law school graduation.
Oh, cool. Congrats. So now you focus specifically on estate planning. Or that's what it kind of see. Is that would that be fair?
Yes, that's correct.
Like what was it about estate planning that got you excited or that kind of led you to focus just on that?
Yeah, great question. One of the things that I enjoyed doing before I went to law school was writing, and specifically technical writing. And when I had the opportunity in my prior profession to work on contract documents, I really thrived in that role.
Okay.
And that was the type of transactional classes were the ones that I enjoyed the most in law school. And when I graduated in 2012, it was during the recession. So there was
Mhm.
not job opportunities anywhere if I wanted to stay in Des Moines. So I had started putting down thoughts to open my own practice.
Okay.
When you open your own practice, you don't have any clients. And so I
Right.
started out with a general practice, but I enjoyed the transactional work the most. And 3 years ago, I decided to fully focus just on wills and trusts and probate. And I enjoy it a lot because I'm able to do more focused continuing education, really get in the weeds in terms of the interpretation, the court's interpretation in case law, and
Yeah.
understand the probate statute, which is quite long. And the ability to practice I do a few wills a week. I'm able to answer questions pretty easily and make people comfortable because I talk about it
Yep.
every day.
Yeah.
And therefore, it makes people more comfortable with the information they get because
Right.
I can provide it in a sort of no nonsense, layman's terms description.
Yeah, that's what I have been kind of attracted to your practice for that fact that you're having the same conversations with people every day. And so you're super efficient. The cost is a bit lower than traditional, uh, you know, estate planners usually charge. And that probably some of that comes from like, this is you're really good at this now because that's all that you do.
Mhm.
Yeah.
Yeah, yeah. The efficiency and repeating the same type of cases definitely helps. Um, I also find that the people that I work with have um, typical assets of young professionals or people entering retirement, which is they have a homestead, possibly a vacation home, vehicles and retirement accounts and investment accounts. And because of the in Iowa, there's no estate tax and the federal estate tax is so high, I'm able to serve a large group of people that may otherwise not go to a larger firm to get
Right.
estate planning done because it might be cost prohibitive.
Yeah.
And their estate is pretty straightforward and something that I see on a regular basis. So I am able to provide a, a reasonable fee and a flat rate
Yeah.
for
That makes
that.
sense. Would it be fair to say that there's kind of two paths to go down? You can kind of do the will-based estate plan or a trust-based estate plan?
Yes, those are the avenues. Another important part is your assets as they are held, as they're owned. And
Right.
so a will and a trust, or a trust, or both, don't dispose of all of the assets at death. Part of my will in a day package, revocable trust package, is going through the assets that the person owns and identifying the type of asset it is and whether they have a beneficiary option or a payable on death option.
Right.
So in a lot of situations that I see, there's probably 60% of the assets don't actually use either of those documents.
Right.
And when I started practicing in probate, which is the court supervised process of transferring or selling an asset after a person dies, I learned that if people had some estate planning, or I call it asset transfer because estate
Right.
planning sounds like
Right.
really old school, I guess.
Right.
I learned that, with some education and instruction, people can keep their assets out of probate and allow them to transfer easily to their heirs.
It's all about making sure that assets go to the right owner. And so,
Right. Yeah.
the will, the reason that the trust stays outside of probate is because technically the owner never dies because it's the trust.
You do
Okay.
need both. So if you
Right.
have a trust, you also need to have a will, but the will is typically called a pour over will, which directs all assets other than your personal belongings to
Okay.
go into the trust. Because there may be some asset that you completely forgot about and it's not titled in the trust, it doesn't have a beneficiary, and therefore you want the will to say that it's going to go to the trust.
Okay.
So if you have
So,
let's say you have a bank account that's you forgot, like maybe you inherited an account as a joint owner and it was $60,000. So that exceeds the $50,000 limit.
right.
And when you pass away, you didn't have a payable on death, you didn't retitle it in the name of the trust, then that asset would transfer under your will.
That makes
So you
sense.
would need your will to say any assets that don't have a surviving joint tenant or a surviving beneficiary will
Right.
transfer under the will.
Like the pour over will. So if you purchase any more assets after the will is created and you forget to title them in the trust, the pour over will is going to kind of come in and save your butt and
Yes.
include it in that estate.
Yeah. Yeah. It's
Okay.
a safety net. Hmm.
Cool. Is there situations where you would not recommend someone do like a revocable trust for estate planning issues?
Generally, no. If they don't have a home, like primarily the individuals I work with, the main part of having the trust is to transfer the real estate into the trust. Because if there's no surviving owner of real estate and it's in Iowa, then probate's required.
Right.
So if a person doesn't have real estate, then there may not be anything to transfer into the trust.
Mm-hmm.
And that would also be like they have adult children and they want the children to have their inheritance outright and not
Right.
have it be held and managed by a trustee.
Right.
So let's say there's a retired person, um, uh, let's say 65, and they don't have a homestead and all of their accounts have beneficiary designations and then they have a payable on death for their bank, then a will to transfer their personal property would be all that they would need.
The transfer of the assets is the big thing, but like with the will creation, there's some other end of life documents that are really important to have, or for even young families, like instructions what to do with children or even pets. Can you talk about that a little bit?
Yeah. So for adults that have minor children, in the will, they can appoint a guardian in the event that both parents are deceased and there's a child who's under the age of 18. And in the Iowa Code section for guardianships, a person nominated in a will as the guardian has first preference. And therefore, it would be a lot smoother of a process to get a guardian appointed. So even if somebody's appointed in a will, they still have to get court appointed.
Right.
But the process is much easier if they're named in the will. Whereas if there isn't a will And let's say there's grandparents that both want to be guardians because they want to be able to make sure they see their grandkids and they want to help
Right.
raise them. The court is not going to appoint two separate families to be guardians.
Right.
And then that creates a contested guardianship
Right.
in court, and that's not what anybody wants.
Right. Yeah, I could see how that could be very problematic. Is there a way to avoid the court process of appointment, or is that something like guardianship that no matter like what estate planning documents you have in place, that's always going to be need to be approved by the court?
Yeah, the way the guardianship law is written now, there's no way to have the court like it's called a standby guardianship. So
Okay.
there's no process to do that. But if somebody is appointed in a will, then when they petition to be appointed as the legal guardian, and it lasts until the child's 18,
Okay.
when they petition to be appointed legal guardian, then it's a much easier process for the court to, because they have the parents' input because of the will.
Right. One of the things it seems like that's kind of a big or I think we've talked about this before. One of the things like that some people kind of miss the boat on is that they've got this document in place now, but they didn't fund the trust
Oh,
or title things the way they should. So how does the pour over will come into play there? Is it like any assets that was purchased before the date of that the pour over will was executed would not be included in that? Or why would you have to fund the trust if you have a pour over will?
yeah, that's a great question. So there's two steps to a trust. First is you have a trust document, which is a legal document that you sign as the grantor, which is the person that creates the trust
Yep.
and who is transferring assets, their own assets into the trust, or will be. And so there's a trust document that it names the grantor and then also names a trustee. The
Okay.
person that is creating the trust is often the trustee during their lifetime, and then they have a successor trustee. So the trust is created by a legal document, and then you have to fund the trust with an asset. The transfer of a homestead into the trust by a quitclaim deed would be one way to fund the trust.
Mm-hmm.
And then the only way other assets could be titled in the trust or get transferred into the trust is if the trust is a bank account is in the name of the trust,
Right.
if a beneficiary designation is to the trust. And
And that's one thing that we see a lot. We run into people who have no beneficiary designations on your statement. And so if if anybody watching this, if you want to go look at your statement and any account type that's not an IRA, it should say like TOD or POD after it. And if it doesn't, then you would want to, talk to your advisor about getting that set up. So I'm still wondering like if the pour over will says, hey, all my assets go here, then what's the purpose? What do we need to fund? Why would we need to do the quit claim deed on the house? Why do we need to do the POD, TOD designation on the banking accounts and other investment accounts?
yeah, why should you retitle things into the name of the trust? I'll use the example of real estate. So if a person, if there's a single person who owns real estate in Iowa and they pass away and the deed is in their name only, it will transfer under the will. The proceeds will go, or the transfer of the asset will go to the trust, but because it's the owner is deceased, Iowa law requires the probate process for the
Okay.
transfer or sale of the real estate. So the pour over will would still get it to the revocable trust, but it would only happen through the court supervised probate process,
Gotcha.
which is what you're
So
trying to avoid when you create a trust.
you do need to be a little bit disciplined when you create a trust because um it like if you bought a different house or a piece of land, if you're like you are a farmer, you have to make sure, or you have to have someone in your corner like an attorney like you or a financial planner like me to make sure that gets updated, because you could go through all this work, doing all this planning, and still have to have a court process, which isn't the end of the world, but it's just another step that can be avoided at a time when you're probably going to be grieving anyways.
Right. Yeah, you're exactly right.
Like, does the law ever change that would require wills and trusts to be updated and things like that?
The tax laws for estates would be something to keep an eye on. Federal estate tax is paid when the entire value of your estate is 11.7 million.
Right.
So those are not the people that I work with. They go to, larger firms,
Right.
rightfully so.
Right.
They're equipped to handle that, and they have the team to handle that.
Right.
At one point, I believe the federal estate tax was 3.5 million, which would gather in quite a few more people if
Yes.
you have investments and accounts that would exceed that amount if you passed away.
Right.
So if the federal estate tax gets into the single digits and into the
Right.
million, then there would be a need to update, or at least talk to an attorney
Right.
or a financial advisor about whether some tax avoidance legal documents should be put in place. And it's really relevant for Iowans that own farmland, because then you can get into the millions really quickly. Since I work in the city of Des Moines and I primarily serve Polk County residents,
Right.
I do refer out estates that involve farmland because it is a more
Okay.
complicated process.
Right. That makes sense. What recommendations do you have for people about making sure that your survivors uh like have passwords to your online accounts? Our lives are getting more digital, and you know you can recover a lot of that stuff, but in some instances you have to have a death certificate, which doesn't come right away.
Yeah.
And if you need to, for example, need to transfer some cash in a checking account, and you got to wait, maybe you got to pay for a funeral or whatever, and you got to wait a days until that death certificate's there. What kind of advice do you give people as far as how to share that information?
Yeah, that's a terrific question, and one that I think of more frequently every week in terms of my own passwords. And I just watched a HBO documentary called Generation Hustle, and there
Okay.
was an episode on a rapper that started scamming people online involving credit cards and other things when he was 13, and so that was very frightening.
Right.
um, Talked about the dark web, things that we don't really like to think about, but
Mhm.
when I started my practice, I started with a password manager, which is a platform where you have one long password that
Right.
unlocks the vault of all your other passwords. And then it has a security key for somebody, for like my executor. So I have the security key printed and with my will in my safe. And then I've told my executor where my will is, how to get into the safe,
Right.
and that all the information to get to my passwords is there.
Right.
Some people are
What
not comfortable with online storage of passwords. So I tell people whatever you're comfortable with, just please don't leave your executor in the lurch of trying to figure out how to cancel
Right.
your Netflix subscription. I mean, we're getting to around like 50 usernames and logins, usernames and passwords per person, and it's just going to
Right.
get harder, and they're getting much easier to hack.
Right. What service do you use for that, if you don't mind me asking?
Yeah, I use 1Password, and I
Okay.
think another one that comes up often is LastPass.
That's what I use.
Mhm.
I like LastPass. I need to, and I'm just thinking through this myself. That's why it's helpful to have conversations like this with professionals, because I don't think I have my master password like located inside my estate planning documents, which kind of just
Oh,
shows you like how useless some of this planning could be if the right people don't know where the right information is.
yeah.
I know you see people virtually, you see people face to face, like how that works, and then kind of like rough costs are for the different types of packages.
Yeah. So I've tried to make it as transparent, as convenient as possible, especially if people are comfortable with technology. So appointments can be booked online at my website, hopewoodjd.com, and you can pick the date and time. If you select a virtual meeting, I do it like this by Zoom, and I share the documents, and we review and work through the documents and the asset transfer worksheet together. That takes an hour. And then there's a signing meeting after they've reviewed the documents and we finalize them. So total time is about 90 minutes for that. If they select in person, we do the whole thing in one 90-minute meeting.
Mm-hmm.
I do get an intake ahead of time, so I have the draft started and
Okay.
they can include their questions. The flat fee right now is $450 for a single person, and $700 for a married couple. And so $700 for a married couple includes a will for both of them, powers of attorney for both of them, and an asset transfer worksheet. So both packages, you get all those documents, powers of attorney, last will and testament, and then the asset worksheet. And then the revocable trust package is $1350, and that includes the trust, a quitclaim deed for the homestead, last will and testament, the 2 powers of attorney, and the asset transfer worksheet. So that you can also book online. And if somebody just wants to do powers of attorney, to at least get those in place, a power of attorney package that it's $150.
Okay.
And that can be either all virtual, because I'm a remote online notary.
That's what I was going to ask next. So the entire process can be virtual, correct?
Not the wills. In Iowa, the wills currently have to be in-person witnessing.
Okay, gotcha.
But the powers of attorney is a notary, and I'm a remote online notary, so I am able to do all that virtually.
Okay.
I also want to say that I do go in home
Okay.
if individuals are have health
Yeah.
issues. I'm able to go and travel to the house. I have a travel printer that I
Yeah.
take with me, and that takes about 2 hours.
Yeah, that makes sense. I'm really excited about this. Like I think I told you earlier, is this is absolutely the most overlooked planning area. Like when we see new or prospective clients, this is like the thing that nobody's talked to them about yet. And I guess some of it is because financial planners don't get paid to make estate plans. But I just have this really I think it's my responsibility to make sure people get to the finish line on this, because we can tell people like what is the right thing to do. Even in our personal lives, we know there's other things that we maybe should be doing, but we don't always prioritize it.
I think the hardest thing is just to make the appointment. I think there's just this feeling like, well, I don't have the time, or I don't know all the answers, or I don't want to disclose this information. I'm embarrassed that it's taken me this long.
Right.
So my recommendation is just book the appointment, and then I take care of everything else. I walk people through it. I've served over 1,000 people in my practice, and I have Google reviews where people share their experience, that it was very stress-free, gave them peace of mind.
Right.
So keeping an eye on the finish line and just taking that first step to make the appointment.
I've had a conversation with people before, and the reason they haven't started the process is because they don't know exactly who like the executor is going to be. Because maybe there is no kids, or maybe it's not going to be the kids for some reason. But I would say, that you have to go through the process at some point. So even if you don't have all the answers, it would be good to sit down and brainstorm with somebody like you and start working through it. And, worst case scenario, you got to finish the process later, but at least that's a huge step, getting a lot of other stuff taken care of.
Yeah, and it's better to get the documents in place because it's much easier to amend them
Right.
than to have the initial one. Again, even if it's just powers of attorney, it's much easier, even if you don't need them, to just get them in place, because then you've got them, and it's only a matter of amending it if your life situation changes. The
Yep.
question that I ask people when they're unsure of who to appoint as a guardian or as an executor is, I say, someone will have to ask the court to be appointed in that role. If you're okay with, one of your family members asking the court to be
Just
appointed,
volunteering.
yeah, like who do you want that
Okay.
person? Who would you want to ask the court to be appointed?
Right.
And then that sort of like, okay, well, it does have to happen, and I know they usually know who they don't want appointed, and
Right.
so through that process, they can come up with someone. And I tell them too, if it's a parent as a executor or guardian, and they're concerned about the parent aging, I just say, it's very easy to amend a will. It does require having it witnessed and notarized again, but getting it in place is much better and amending it later is much better than not having anything.
Right. Right. Yeah, that's great advice. Thanks a ton for having a conversation with me. I hope that now everybody's going to go get their estate planning documents done. One more time, what's the website they can go to schedule?
hopewoodjd.com.
Cool. And I'll put that in the notes also. You have any questions? Hope would love to help. And I hope you have a good rest of your day.
Thank you very much, Logan.